Hey everybody, Teaching Tuesday again. This is Brett Thompson from the Thompson Law Group World Headquarters. And like I said, this is the Teaching Tuesday. We go over Virginia law pertaining to real estate contracts, real estate law. And let's see, recently we talked about an executor of an estate and how and when can they sell real estate out of the estate. Today we're going to talk about an administrator. So my question for my real estate agents, let's say somebody comes to you and they say, hey, mama died. I'm the administrator of mama's estate and I want to sell mama's house. Do you have all the information that you need in order to enter into a listing agreement with that person? The answer is no. So buzzwords, the buzzword was administrator. If somebody says that they're the administrator, that means that mama died without a will. If they're an executor, that would lead you to believe that mama died with a will. And so if you die with a will, that's called testate. If you die without a will, that is called intestate. So, and also real estate drops like a rock through the estate. We learned that in law school. So for myself, I have a mother and I have one brother. So if my mother, God forbid, were to pass, and she did not have a will, by operation of law, her interest in her real estate would pass to my brother and myself as her heirs at law via intestate succession because she died without a will. Now, how does that apply to you? So, if an administrator comes to you and they say, hey, mama died and I'm the administrator of mama's estate, just note that an administrator, as opposed to an executor under a will, cannot convey real estate out of an estate. So you don't particularly have all the right people on the bus. So if it were my case, if mama died without a will and I'm the administrator, you would need to deal with the heirs, which would be myself and my brother. And so myself and my brother would need to sign your listing agreement. We'd have to sign the contract, and we'd have to sign the deed and the other closing documents. There is an exception. If the administrator petitions the court, all right, and the circuit court in the jurisdiction where the real estate lies, enters an order authorizing the administrator to convey the real estate on behalf of the estate, that would be the one exception. So if you have an estate where there is no will and an administrator is appointed, you need to ask if there's a court order out there authorizing the administrator to convey the property in their capacity as the administrator. If you do not have that, then you're not dealing with all the right people. You need to find out who are the heirs at law. And the heirs at law would be listed on a list of heirs, which would be recorded in the land records. So whoever the heirs are on the list of heirs, that's who you would need to seek out. That's who you would need to join in your listing agreement, your contract, and the actual closing of the sale of the property. So if we have a will, we have an executor. If there's no will, we have an administrator. If we have an administrator, we have to have a court order in order to deal with just the administrator. So I hope that clears it up. I hope this was another fun Teaching Tuesday, and we'll see you next Tuesday. Thanks a lot.